This courtroom clash kicks off with a serious accusation that could shake the foundation of the entire case, claims that jail staff may have accessed privileged attorney-client materials. If true, that's not just a minor procedural slip, it could impact the fairness of the trial itself. But here's where it gets intense: the defense wants penalties reduced, while the judge demands hard proof, not speculation. As tensions rise, watch closely, because this isn't just about what happened, it's about what can actually be proven. And that line? That's where cases are won, or completely fall apart.
Commonwealth versus Thomas O'Donnell, 22 CR 00103. Mr. O'Donnell is present. His year of birth is 1961. Last four digits Social Security number 6773. We have a motion to secure attendance.
Yeah, that's our motion for out-of-state witness, Your Honor.
Is there any objection to that on behalf of the defendant? Okay, and then you have a motion to reconsider. You want to state that?
Yes, Your Honor, if I may be heard on that motion. That motion was a request to reconsider, or primarily for the court to go ahead and dismiss the enhanced penalties that had been noticed based on the information that has been submitted. So, Judge, this remedy that we're asking for is a narrow remedy that's grounded in fairness. So this case involves a government intrusion into clearly marked attorney-client privileged legal materials. And those exhibits have been submitted previously and reattached to this motion. It's undisputed that jail staff opened and went into these materials, which contained defense notes and strategy. It's also undisputed that case-related...
I don't know that that's undisputed or not. Come up to the podium. It's undisputed that the jail people searched some of his papers.
It's undisputed that his notebook was searched.
His search, but
It's
the Commonwealth
disputed.
says that you don't know what was in it.
We don't know what was in it. State police investigated the matter. There was nothing of any significance reported to them that the jail staff saw. So if the jail staff was trying this case, I think they might have a valid argument. But the Commonwealth or the Commonwealth's agents that's going to be witnesses in this trial do not have any access to any
So I don't know how I
privileged
can
material.
restrict. I've already ruled on this. We've had a long argument on it. How can I restrict what I do not know existed, in which the Commonwealth says it has no knowledge of it? Now, what do you want me to specifically restrict?
Judge, and this isn't an issue as to whether these materials...
Answer the question that I posed to you, please. What do you want me to restrict?
The availability of enhanced penalties.
Well, I'm not going to restrict the availability of enhanced penalties on something that is not going to be used. The Commonwealth says they have no knowledge of it. So I'm overruling your motion. Okay, is there anything
Judge,
else?
May I just finish making a record of the motion, even if the court...
Surely.
Okay, thank you. Judge, these members from the jail were interviewed, such as Christy. And in this interview with police, she communicated some of the case-related information that had been ascertained from these materials. And again, these were materials that were clearly marked as legal materials. We know that pretrial incarceration does not diminish the attorney-client privilege. Kentucky law expressly protects confidential legal materials. Again, those materials were marked, and it's unfair to say that case-related information was not communicated from those books, because we know case-related information was communicated to Mr. Wright with the Commonwealth's Attorney's Office, and we know that case-related information was communicated to Mr. Stockton.
Could you be more specific?
You want to be more specific?
I don't know what you're referring to.
The Commonwealth says it's not aware of what you're talking about.
And Judge, that's the issue. I don't want to diminish the privilege further by now relaying this confidential.
I've had all of this argument that I want to hear. You're asking me to reduce the charges or possible penalties against your client upon a thin gruel, a thin soup that's made out of as Abraham Lincoln said, that's made out of a shadow of a crow that starved to death. I don't know what you're talking about. The Commonwealth says they have no information that they received. And I'm not going to diminish the serious charges against your client predicated on something that might have been seen that I don't even know would affect your defense in this case. So I don't have enough information. And if I did have enough information, the only thing I could do would order the Commonwealth not to use any information or any fruit thereof. And that's a different remedy than you're requesting. Your remedy is out of proportion with the allegations you made, in my opinion, and that's the ruling, okay?
What we just witnessed is a textbook example of the gap between allegation and proof inside a courtroom. The defense raised a serious constitutional concern, potential violation of attorney-client privilege, which, if proven, could have had major consequences. But here's the key issue. They couldn't, or wouldn't, provide specific details to back it up. And in court, that's everything. The judge made it clear, without concrete evidence showing what was accessed and how it impacted
Yes, Your Honor,
the case,
if I may be heard on that
there's no legal
motion.
basis to reduce charges
That
or
motion
dismiss enhanced
was a request
penalties.
to reconsider
Instead,
or
the only possible
primarily
remedy would have
to,
been
for the
limiting the
court to
use of
go
that
ahead
information,
and
not
dismiss
throwing out
the
the
enhanced
consequences
penalties that
entirely.
had been noticed
So now the
based on
question
the
turns to
information
you,
that has
should the
been
court have pushed
submitted.
further to
So,
investigate,
Judge,
or was the
this
judge right to
remedy
shut it
that we're
down without
asking
solid
for
proof?
is a
Thank you very much. Is there anything else anybody has on this case?
Not today, Judge.
Thank you.